Namaste. Good morning. Welcome to AAA Weekly Webinar Series. Today we have with us Mr. Debajyoti Chaudhuri, the Managing Director of NeSL, National E-Governance Services Limited. This is the only organization which is a public sector organization, probably, in case I'm wrong, I think Mr. Chaudhuri will correct me, which is presently given the mandate of running an information utility. So today the subject that we are going to handle is what is the importance of information utility, what was the original thought when this particular IBC was formed, how the insolvency information utility will grow in future, and we will also have the expert comments from Mr. Debajyoti. So this is, I think, Mr. Debajyoti, I think in the beginning, what exactly you would like to say, then I will take up the entire importance of information utility and what all sections it is important and what is the role of information utility. And then we will come to the proposed amendments and we will seek suggestions from participants for any kind of change or any modification they need in the discussion paper or in the proposed amendments.
Yeah, thank you, Anilji. And I've been seeing these webinars being conducted over the years. And in fact, initially I was participating also, but now due to constraints of time, I've not been participating. But I keenly watch these. I hear about these. This is a success story about bringing about awareness about IBC and various aspects related to it, whether it's case laws, whether it's NCLT orders, whether it's IBBI discussion papers. Now, coming to the information utility, I mean, to start with, I would say it is one of the 4 pillars of the code, and it is a unique institution. The IBBI website says that there's no panel anywhere in the world. Now, the genesis of this utility we can find in the ALRC report, and it refers to something called information symmetry, information asymmetry. Information asymmetry, the ALRC says that it could be a barrier in negotiations between the debtor and creditor, and idea is to remove the information asymmetry, and which should lead to fair negotiations between the debtor and creditor. And also, it is a kind of proof of default which the AA can use so that admission processes can take place very smoothly. Now, the question I'm often asked is the term information asymmetry. So, how the information utility or NeSL helps to address? So, one very simple way it does is, I mean, there's a process of authentication of information of default once the creditor submits information. Once this authentication takes place, and as provided in the regulations, NeSL as the IU sends something called a default broadcast to all the creditors of the debtor. So that means even if a default is happening to one creditor, so all the creditors are made aware of the same. The benefit for that is that other creditors, even where default has not happened, they can take appropriate risk mitigation measures, which could mean if they have some undisbursed limits, so they can renegotiate on that. They can take an additional security margin to protect the interest. Now, there's one more aspect to this. The record of default with the IU issues, which also helps the AA, in case of IBC, it's NCLT, decide whether a case can be admitted.
First, give a little bit of perspective about overall scenario of financial information in India. Now, the financial information, when we see that the financial information is something that is required for various reasons. So there are various kinds of financial information which are available on public domain, based on various efforts by Indian government to bring the transparency in the financial information. So there are many usages of these financial information. So information utility is one of the source for financial information about parties, about persons. Now, the government have been trying about this kind of transparency in the financial information about persons, all kind of persons. And the first such effort was made in 2005 when the Government of India brought this Credit Information Companies Regulation Act 2005. Under that act, which is regulated by RBI, under that act, we can see the companies like CIBIL, Credit Information Bureau Limited, the companies like Equifax, Experian, and High Mark Credit Information Services. However, this particular information, this particular mandate by the RBI is only limited to the credit history of a person. So if a person is not borrowing, even on the credit card, there will not be any history of a person. What is the financial information about that person? The CIBIL-like companies, like credit information companies, they are restricted to all kind of information from the banks and the credit card companies, from all kind of lenders. There is a system called credit scoring system in this. Then the other kind of information which is available on public domain is various kind of agencies which registers the kind of registration of various assets. Maybe the registrar of documents where all the real estate transactions are registered. Maybe the registration for vehicles, Motor Vehicle Act, where the registration of shares and securities as per SEBI. Then the registration of ships, registration of aircraft, registration of trademarks, registration of copyrights. So these are various registration authorities where the assets are recorded, that these assets are owned by so and so person. Then we can even go to the another kind of regulated, like we have this MCA, the MCA 21, Ministry of Corporate Affairs, the records of a registrar of companies, where the charge information or the financial information, but this particular MCA 21 is restricted to companies as well as LLPs. Then, of course, we can see the central registry, the CERSEI. The CERSEI is again a financial information company which is only and only limited to the registration of security interest from any lender, which is bank, NBFCs, and the ARCs. So this is the overall scenario where the financial information is important. So when we see this financial information, see the information utility is one of the effort of the Government of India, where the financial information about persons would be available. That may be required for handling insolvency, that may be required for giving a loan to a particular person, and that may be required even for dealing with a person for a normal business transaction. The original concept of information utility was that it will cover everyone. It will cover even those transactions. Now, for example, company A wants to sell steel to company B, and the company B is asking for a 60 days credit on every invoice issued. So there is an agreement. However, in that agreement, there is a condition that this company A and the company B, company A says, I will extend credit to you for 60 days, but I will upload all my transactions to information utility, so that at every point of time, you will have to accept that transaction. And if in case you will not accept that transaction, I will stop giving you the credit, or I will stop supplying you the steel. Similar transactions, it is the original concept is that all such kind of transactions would be registered, and information utility, as we have seen, NeSL, the bankruptcy reforms committee were basically thinking that there will be a competition in the IUs. There will be many IUs, and the public at large will use IUs for their normal transactions of extending credit, taking credit. That means that every kind of information, financial information, will be available on one or the other kind of public domains. For any security interest, SARFAESI, for any charge on the assets, ROC, in case it is a company or it's an LLP, SARFAESI is applicable to everyone, irrespective of whether it's a company or LLP, and all kind of transactions between private parties, which is not lenders and the borrowers. Then the information utility was actually filling the gap. The information utility, in fact, is in existence since the promulgation of IBC in India. However, the resolution process, because see, what is the objective? The objective of the information utility was that the resolution process should be swift and efficient, and it should improve the efficiency, enhancing the effectiveness and acceptability of the records of default. So the record of default as issued by information utility is a very, very important document for taking a swift decision, efficient decision, and also the authentication done by the IU is also should be robust and standardized, and also it should be rigorous. Therefore, it actually will establish the defaults in front of the adjudicating authority. It is a high quality of authentication is required, and also it will expedite the process of insolvency. So when we say all this, and when we try to see the Bankruptcy Law Reforms Committee, it actually says, now I will read what actually the committee said. Before the insolvency resolution process can commence, all parties need an accurate and undisputed set of facts about existing credit, collateral that has been pledged, etc. Under the present arrangements, considerable time can be lost before all parties obtain this information. Disputes about these facts can take years to resolve in courts. The objective of an insolvency resolution process that is completed in no more than 180 days can be lost owing to these problems. Hence, therefore, the committee envisions a competitive industry of information utilities. Competitive industry of information utilities, that the committee in fact had a vision that this will not be one IU. There will be many IUs, and it will be a self-survival kind of a model where the business people or even otherwise, they will come and register their transactions so that in case of default, the record of default can be taken from the IU, and immediately the recovery process or legal process can be started. This was the vision of Bankruptcy Law Reforms Committee, BLRC. And therefore, when the insolvency resolution process commences, within less than a day, undisputed and complete information would become available to all persons involved in the insolvency resolution process, and thus addresses this source of delay. This was the original vision. That vision needs to be achieved. Therefore, the original understanding of the BLRC is yet to be seen. So the entire process of verification of a transaction, that is where the discussion paper is required, and that is where the discussion paper is focusing on. Now, we actually can see the aim that we have already said, that what is the aim, but then what is the importance? Like, I would further emphasize that in case we see section 3 subsection 9, actually which means that the IU is mandated to provide core services under section 3 subsection 9, means services rendered by an IU for accepting electronic submission of financial information. It is all about financial information, safe and accurate recording of financial information, authenticating and verifying the financial information submitted, provide access to information stored within IU. Now let us understand what exactly is the meaning of financial information as per code. As per section 3 subsection 13, the code says that the financial information in relation to a person means one or more of the following categories of the information, namely records of the debt of a person, records of liabilities when a person is solvent, records of assets of a person over which security interest has been created, records, if any, of instances of default by a person against any debt, records of the balance sheet and cash flow statements of a person, and such other information as may be specified is the full definition of financial information. Then we go to section 3, subsection 21, which actually defines information utility, means a person which is registered with the IBBI, because for every information utility, the first requirement is that it should be registered with IBBI. Then we see the usage of IU in section 7, subsection 3, clause A, which specifies that a financial creditor shall, along with the application, furnish record of the default recorded with the IU. Of course, it is written, or such other record or evidence of default as may be specified. Then section 7, subsection 4 says that the adjudicating authority shall, within 14 days of the receipt of the application, ascertain the existing of a default from the records of an information utility, or on the basis of other evidence. Of course, these other things are also getting similar provisions are there in section 9, subsection 5, that is for operational creditor, and the similar provisions are also there for the adjudicating authority to accept an application if it is along with the record of dispute. But very important is that the Honorable NCLT, in fact, issued an order on 3rd of April 2023, where the in order which is consequent to the regulation 20, sub-regulation 1, capital A, which was added to information utilities. When that regulation was added, and it was added on 14th June 2022, then the order passed by NCLT was that all the petitioners of section 7 and 9 under IBC have to file information of default with IU, and the IU shall process the information for the purpose of issuing record of default in accordance with regulation 20, sub-regulation 1A. Now, Mr. Chaudhuri, this is where the immediate importance of IU surfaced, because before even we file any section 9 application, before even we file any applications under section 7 application, the record of default has been made a must. So after this NCLT order of 3rd of April 2023, can you just guide us, like what kind of change that you have seen in the data which is coming, and how much time it is taking for the IU to give a record of default? Mr. Chaudhuri, please.
Yeah, thank you. So let me just say a subtle point here. If you see this 21A, if you see, if I just read it out, it says that before filing an application to initiate corporate insolvency resolution process under section 7 and 9, so basically only for financial and operational creditors, the creditor shall file the information of default with the information utility, and information utility shall process the information for the purpose of issuing record of default in accordance with regulation 21. Now, this has to be read with section 7 of the code. Section 7 of the code says that you have to use along with the application, you have to enclose the record of default or any other information which is specified, and this information has been specified in the CRP definitions. So effectively what it means is that as of now, it is mandatory to submit information of default to the IU. So that is a mandatory requirement, but if you read with section 7, it's not mandatory to enclose the record of default along with the application. Now, as far as how much time of and before that, Anilji, I would like to just draw the attention of viewers to section 250 of the code, and that's where the IU functions. So 215 of the code says that, and just in fact, I'll just read it out. Just open one moment. If you see. Yeah, section 215(2) of the code say, it's 215. 214E. 214E says the information utility shall get the information received from various persons authenticated by all concerned parties before storing such information. So the mandate of the code is very clear that once the information is submitted to the information utility, the information utility has to present the information to all concerned parties. So who are these concerned parties? If the creditor is submitting information, concerned parties are the debtor and guarantor, which is most common. It could also be a co-applicant in such cases. Most commonly, it is a debtor and the guarantor. So 215E of the code says that we have to present the information to the concerned parties of the debt before storing it. Now, as far as information of default is concerned, I have to read with 21. So once the information of default is presented to the IU, then this information, and in consonance with 114, we have to present to the concerned parties to the debt. And how this is to be presented? That is again given in the IU regulations, and this is basically regulation 21, which refers to, which provides for authentication of default. And regulation 21 says that IU shall expeditiously undertake the process of authentication and verification of information of default as soon as it is received. Now, NLG asked a question as to how much time it takes for this authentication process to take place, and this is very relevant because some amendment is made in this process, and which is of a lot of significance. So if we see regulation 21(2), it says that you have to deliver the IU has to deliver the information of default to the debtor, seeking confirmation of the same within the time specified, and then remind the debtor at least 3 times for confirmation of information of default. And if the debtor does not respond, allowing 3 days each time for the debtor to respond. So effectively, what it means is that we have to give one original request for authentication of default, followed by 3 reminders, and giving 3 days time before sending each reminder. So effectively, what it means is that one original plus 3 reminders. So 4 into 3, that is 12 days. And then you have to give after every, because you have to wait for 3 days. And before you send the next reminder. So we need to add another 4 days for each of these. So as of today, the minimum time which takes to issue a record of default is 4 into 3, 12, plus another 4 for each of these 4 days. So that is the minimum time is 16 days. And this is the very ideal scenario. Now, if the mail is not delivered, so we have an automated system of sending the mails. So it will keep on trying. So if that doesn't happen, so then a couple of days may take place here and there. Of course, in a situation where the corporate debtor immediately accepts a default. So it can happen within a few days also. But our experience is that default is an event where the corporate debtor is very unlikely to accept. So the minimum time which we take to answer this question is that 16 days. And of course, when we come to the amendment, we'll see how IBBI proposes a change in that.
My one apprehension in the case of Section 9 applications, the applicant is also supposed to give a notice under Section 8 to the corporate debtor first, to the defaulter. No, that notice go first or record of default comes first. This is one kind of apprehension that I have, that if I give notice first and then file the information to IU, then the other person will never accept it. It will not be even a single case that if I give notice first and then I file the financial information to IU about that transaction or transactions, then the defaulter will never accept that there is a default. What is your experience? Because in fact, the discussion paper also says at a particular paragraph that there are hardly few instances where the default has actually been accepted by anyone. So there has not been acceptance, there has not been rejection. So this is something where the very few people have reverted even. So one, that it was an issue of which is the appropriate email. Then of course the 3 days was considered as lesser. Of course that amendments are coming. But my only question is that if this has actually been made mandatory, so the notice goes first to the debtor, to the corporate debtor by the operational creditor under section 8, and then after 10 days I can only file my application under section 9. Now after this I am also supposed to file this information to IU and it will never be accepted. So what do you say about it?
See, my personal opinion is that what is the purpose of notice? It is giving an opportunity to the corporate debtor to either pay up, or if he has some other view about dispute, for example, so he can exercise his dispute. So my personal view is that if a corporate debtor uses, or if the operation creditor uses the facility of IU, we need to really consider whether if notice is required or not. Because when a request for authentications goes from the IU, is it not akin to a notice? Because notice, again, you are sending to a dependent agency, you are getting a receipt for that. So all these facilities are being provided by the information utility itself. So if a creditor, if an operation creditor desires to use the facility of value, my opinion is that maybe the requirement of notice can be dispensed with. And when he gets a request to authenticate, so that should be akin to treating as to a notice. Because like in a notice, we get a proof of delivery. So similarly, information that we also, when we send an email, we will also give a proof of delivery. So the debtor has been given this information of default. And very importantly, when he authenticates, means
So you have
either of these options are done with a digital signature. So this, I think, should be equally acceptable. And
so this, of course, Mr. Chaudhuri, this will require change in the code, and let's see when it happens. But for the time being, this is the process that first we give notice under section 8, and then we register the transaction with the IU. But I just need to understand, like when we see a particular operational creditor, he might be dealing with that particular corporate debtor for various months or various years. And when we see the notice of default, it has to give along with the all the invoices, along with the ledger account, and along with the bank statement where the payment is received or not. So when this is the kind of notice where you're supposed to give, and when we file application to under section 9, it is also the regulation, amended regulation says that you have to file the GST, copies of the GST return where you have shown that sale of service or goods. Now, when it comes to IU, when we come to IU for registering a transaction, and the transaction may have the data of last 5 years, because there may be some invoices which are outstanding for the last 5 years, there may be some invoices which are outstanding for the last 1 year, or even for last 10 years. So how does the IU take transaction by transaction, invoice by invoice, or it can actually take a transaction which is a consolidated transaction of all these years? How this IU accept the transaction?
See, in the IU, every transaction can be treated separately. Now, I'll just give you the equivalent of a bank does. So a bank, it treats every account, in fact, we call this record. And a record comprises of the account number of the loan account of the bank, along with the PAN number of the submitting institution. So that becomes unique record. If you see our website, we have more than 4 crore records. So ideally, every single transaction becomes a separate invoice. I mean, every invoice becomes a separate transaction. But in case the operation creditor wants to club all of them and send a joint notice, so that can also be done, but it's always advisable to have a separate transaction because it's possible that the CD may like to pay one of these invoices. So then it will be very difficult.
When anyone is registering a financial transaction on IU, it is advisable to register invoice by invoice.
Yes.
So I think there is some fee also that the IU charge for per transaction.
Yes.
So in that case, in case there are 100 such invoices, so what would be the fees for registration?
The fee by registration is 6 rupees per transaction. That's the only
That
fee
is
we
per
take.
transaction. But that is, there is no difference even if the consolidated transaction is registered
Yes,
or if
yes,
it is one
yes,
transaction is registered,
yes,
it is the fee is only
yes,
6
yes.
rupees only. So
Yes.
I think
My only suggestion to register individually was that in case one invoice gets paid, so there should not be any confusion in the A's mind that then some part payment has been done. So that's the advantage of having a separate invoice, and this is especially important if each invoice is more than one thing.
So, Mr. Chaudhuri, just quickly, I will appraise the audience that like section 17 subsection 2 also says that the IRP is vested with the powers that has the authority to access all the electronic records. So the IRP will have the authority to access the records available on information utility. So I would like Mr. Chaudhuri to appraise all the audience how the IRP, RP or the liquidator can access the information which is available on IU. What kind of registration an RP is required to do, what kind of registration a liquidator is required to do, and how the information can be accessed. Is it the information can be accessed person-wise or it can be accessed overall wherever we feel like? Yes, Mr.
Yeah,
Chaudhuri.
thanks, Gurji. This is a very, very important point. And like I said, IP is one of the pillars of the code. IU also. So that's why we made information access extremely simple. In fact, earlier, for accessing two things were required. One is copy of your assignment, and two, you also had to register in the name of the CD where you have been appointed as I. But after I came, I made it very simple. The only thing which you required to do is give your assignment details, and then you will be provided details of your of the CD. And believe me, this is a extremely useful facility. And I'll just give you a few reasons why it could be useful. So one is you can just try it out. We recently did an exercise of information of the IU, which is there, and information of the series as per the COC consumed, because they are now in public. We see a lot of resemblance in that. So one benefit for you if access information, you see some creditors who are there in the IU but have not filed their claims. So this is an opportunity for you to check with them that why have you not filed the claims, because this can lead to unnecessary litigation later where creditor has not filed his claims. Similarly, in many cases you will find that claims which creditors have put as part as subsequent to a public announcement are substantially higher compared to what their information in the IU is. So that will give you some lead, you can put some questions to the creditor that, look, this is what we have filed information in the IU, but you have filed claim of so much. So please tell us what is the difference. And then the third facility which is very useful for the IP is that sometimes when you are, you have to keep the company as going concern. Realization of debtors could be a challenge, because once a company is insolvent, some of those debtors do not pay. So one very simple way of doing this is simply file information in respect of those who are not paying to the information duty. So information duty will start this process of authentication. They will send the request for authentication of default, and believe me, you will get some success in getting repayment of your debtors, and this will improve your cash flows to help you running the company.
Mr. Chaudhuri, I'm reading section 18 clause E, which defines the duties of the interim resolution professional. It is written in that subclause that the interim resolution professional shall have a duty to file information collected with the IU. See, can you just appraise all of us, maybe some of the audience's lawyers and some of the audience. So what kind of information the interim resolution professional or resolution professional is under obligation to submit to IU?
Yeah, so I mean, I am aware of this section, but it is basically once the IP takes charge of a CD, so all the obligations of a CD fall on him. So that's why he is supposed to, if there is some information which needs to be authenticated, so he has to do that information. He needs to do the information. Plus, for example, like I said, that if some default has happened by one of the information, one of the debtors has defaulted, so that information he can file. So these are the things he can do. And
I believe,
of course,
Mr. Chaudhuri, that in case any information that he's collected and it is supposed to be submitted, but then the word which is added there is if necessary.
yeah.
So if you can put some kind of light in what circumstances it is necessary for the IRP to file information to IU, according to your experience.
So my experience is that if one of the debtors is not submitting it, is not repaying on time, so you can submit that information to them.
Okay, okay. So then, see, moving forward to section 18, subsection F, which actually encompasses the powers of the RP and the IRP to take control of custody and control of and the custody on the assets of the company. And one of the clauses that the assets actually which can be verified from the information utility. Now, like what kind of assets that interim resolution professional or resolution professional can get from the IU regarding assets? I mean, I know that many of us do not know that how the IU can help us in understanding the assets of the corporate debtor. Yes, Mr. Chaudhuri.
Yeah. So what happens is when the creditor is filing information, he also gives various details. For example, the securities which have been provided to the creditors for availing various credit facilities. So that is one. Then you also have details like, for example, the offices of the CD, the registered office, and I'll tell you, you get some very useful, information. For example, the various email IDs of the CD. And then we have recently launched this EBG facility. So EBG facility, the advantage is, of course, this is still catching on. I mean, not all EBGs are now on the platform. The advantage in this EBG facility is that a certain contingent liabilities for IP is quite a challenge. So with this EBG facilities, when you log on to the platform, you will be able to see all EBGs or electronic bank guarantees which have been issued by and in favor of the IP. Of the CD. So it will help him ascertain the contingent liabilities. It will also help him know which bank guarantees are coming due for renewal, which are issued in his favor, or where the counterparties have not performed their obligations, and whether he has to invoke those guarantees. So that could also be very useful information. In fact, through the IP logging, he can access all these facilities.
So as I understand, it is not mandatory for any corporate debtor, any company, any LLP to access IU and file their information. In case any transaction is not registered with IU regarding a company, so that company will never show up on the IU. Like on ROC, we get the details of each and every company, and in the case of CIBIL, we get the detail of each and every company which actually has taken ever a loan or has ever taken a credit card or even have ever opened a bank account. So these three conditions, I can get the information on CIBIL. And if a company is registered or an LLP is registered with Registrar of Companies, then I get some information as filed by the company as mandatory under the Companies Act or under the LLP Act. However, in the case of IU, I believe that it is only in case the company has registered any transaction, then only the information would be available. In case the company has never used IU or any of the other party has never used company as a creditor, then that information would not be available. Is it correct what I'm saying?
No, it's not quite correct.
Okay,
Let me
okay.
just
Then
use
I
this
think it needs
forum
to
to
be
dispel
clarified.
that. Yeah, let me use this forum to dispel that notion. As you know, 2015-2 says that all financial creditors have to submit information to that. And RBI has also given instructions to banks, to NBFCs, and also to asset reconstruction companies to submit information to the information regime. So all these regulated institutions, whether it's banks, NBFCs, and ARCs, all these regulated institutions are submitting information to that. And one very important feature of the information regime, and which is not true of companies like CIBIL, is that any information which we submit, we have to mandatorily present the information to the CD. So in whatever information which we have around more than 4 crore records with us. In all of these cases, the CD has been given an opportunity to give his views on the debt. While it is not mandatory for CDs to come and validate the information, but it's mandatory for banks, NBFCs, ARCs to submit information to the information unit. And one more clarity I would like to give, IU has information not just of RBI regulated entities. We have other regulated entities, for example, debenture trustees, which are regulated by SEBI. So they also submit information to that. So when you access as IP, when you access the records of the IU, even supposing the CD has not registered or not authenticated, you can access the information submitted by all these categories of creditors. And of course, there will be quite a few private financial creditors and there will be quite a few operational creditors also who are submitting information. And from this information, you'll get data which could be useful. For example, assets of the CD, offices of the CD, security which has been provided to various types of lenders. Sometimes you find that security has been given only to specific lenders. Each lender has been provided different type of security. So all these details could be there, and also, like I said, about details like bank guarantees could also be there.
So that means that any lender who has given any amount to any person in India, or a ARC, or a credit card company, or an NBFC, they are supposed to give information, one, to civil kind of companies, two, to CERSEI in case there is any security interest, and three, to IU. Is it a fact that every information will go to three such?
Yes, I see. I cannot comment about civil. Civil, as far as I know, it's mostly in the retail space. But as far as IU is concerned, yes. In fact, it flows from the code, 252 of the code, and also flows from circulars of RBI. So this flows from circulars of RBI. Now the issue that just add a line as to why, if institutions like CIBIL were there, why was it necessary to create information to that? And I'll just add a few lines on why it was necessary. The most important fact is the information in the IU is of evidentiary value. So it means when a financial creditor is submitting information, it is submitting under his digital signature. Similarly, when the corporate debtor, if he accepts the information or he refuses information, he does it with his digital signature. So the ROD which we issue is under a digital signature. The significance is that is the information in the information registry is admissible in a court of law. The law does not specifically provide for other institutions that their information can also be accepted in the court of law. The reason it provides for in the case of IU is that every information is to be submitted with the digital signature. And the second part is every information before we accept any information, the identifier, the person has to be identified. So we follow a process of registration and identification of the bond. So for these two reasons, identification and the fact that information is submitted through digital signatures, for these two reasons, the information in IU is admissible in a court of law.
So when was it became mandatory for the lenders to submit financial information to IU, and to what extent it has been completed?
Yeah, so it flows from the code itself. It flows from the code itself, 215.2 of the code. So that itself makes it mandatory. And subsequently, RBI issued the circulars. First circular was issued in 2017, and the second DO letter was issued 2019. Now, as far as regarding the completeness of the information, I would say in the corporate segment, it's fairly complete. And in the non-corporate segment, say the partnership and proprietorship firm, there's a fair bit of submission. And the good part is that many individual records in the individual segment are also with the information. And creditors have realized there are many benefits of submitting information besides the regulatory prescription.
Similarly, Mr. Chaudhuri, there are provisions in Section 36, subsection 3, where the liquidator has actually been given the power that any asset which is evident from the information utility as the ownership lies with the corporate debtor, the liquidator has the authority to take control and custody of that. Similarly, Section 37 also says that the liquidator will have the authority to access the information on all kind of financial information companies, including information utility. Then in case we see the Section 38, which is consolidation of claims, a financial creditor must submit a claim to the liquidator by providing a claim with an information utility. That is, of course, it is along with a proviso that where the information relating to the claim is not recorded in the IU, the financial creditor may submit the claim in the same manner as provided for the submission of claims for the operational creditor. Similarly, an operational creditor also should be. So, like when we see that the entire code and everywhere we actually have seen the importance of information utility, and the code itself says the information utility is very important. And now in case, because of the time also is in a sense, we actually have to see the provisions now where the information utility is coming with a discussion paper, and the mandate that I can see is the time-bound completion of the insolvency process. Then it is actually considered an evidence. However, the admissibility alone is not enough to meet the IU's intended purposes. The swift insolvency, all this is basically the objective. So we can actually now discuss issue, and we actually have to leave some time for the issue one, which is dealt with the discussion paper, is that the sufficient time should be provided to debtor to respond. So instead of 3, now it is 7. So as Mr. Chaudhuri said, that 3 into 4, 12 days, and therefore now it is 7 into 4, so 28 days is the minimum time. Here I would actually seek your indulgence. Now the minimum time after this amendment is carried, what would be with the minimum time to get a ROD, record of default?
Yeah, so let me just clarify. It is 3 plus 7, 3 to 4, 12. But we need to give a gap of 3 days also, because the 3 days has to be complete. So effectively, it takes around 15 to 16. So the equivalent is, so it cannot happen in 20 days, because we have to give a 1 day gap in between to wait for the debtors to respond. So again, under the new, under the proposed dispensation, it will take around 32 days. But idea here is that because for the debtor to come and authenticate, he has to first register. So the idea here is that we are giving them some more time so that he can complete the registration process. But even so, we have to bear in mind that time is of the essence, but then the minimum period of issuance of the current default goes up substantially post this agreement.
So, like, what exactly, in case we can just say, what is the minimum time that actually would be required after this amendment is carried?
32 days.
Sorry?
32 days.
32 days.
32.
So
Again,
32 days would be
16%.
required.
Yeah.
So 32 days would be required. And according to your experience, if the record of default certificate is not attached with the applications are still being accepted, or these are being rejected by the adjudicating authority?
I'll not be able to comment on it. I'll just, I think the law you have already referred to, 21A as well as Section 7. Section 7, it says that you can use ROD or any other. And Section 21A, there's subtle nuance. It just says that you have to submit information to that.
So the issue number 2, which is handled by this discussion paper, is regarding which email ID would be used when we are sending the information to the debtor. So it was basically the email registered with the IU by the debtor itself, or secondly, the email which is used on MCA 21 portal or CERSEI portal, and third, which is submitted in Form C of the schedule by the creditor. Now, this particular email, whatever actually is being used, there are instances that the email is coming back or email is not responding. So there is an amendment now, and then the amendment is not significant. The amendment is that as far as this part C, the Form C email ID mentioned in the Form C is concerned, that can only be used by the banks and financial institutions and not the normal parties. I think 1 minute for you, Mr. Chaudhuri, on this particular proposal.
Yeah, I'm fine with, my only observation here is that in case this MC email ID is it's not valid, if you're not able to deliver email this address, so then it will be very difficult to deliver the information. And what happens if the email, you're not able to use the email, then it goes by registered post. So in that case, the ROD will be, will take a lot of time, because our experience in registered courses is very likely to be accepted by the debtor, and it takes a lot of time. So the concern here is that in case the MC email ID doesn't work, it's not updated, and we find that in many cases MC email ID is not updated, and the debtor is not registered, then the only way to issue the ROD would be sending by registered post, which today's world would take a lot of time. So that's my only concern.
Good. So issue number 3 is the submission of documents by creditors showing proof of debt, proof of security, default, and latest acknowledgement of debt. It was not mandatory earlier, but now it is also likely to be mandated. It will be mandatory that you actually have to submit the documents showing the proof of debt, number 1, proof of security interest, proof of default, and also the latest acknowledgement of debt. That is required. And so it will be, earlier it was not mandatory, so now it is being made. It is the proposal is that it will be the creditors other than bank. They will have to mandatorily, they will have to show and submit the documents of debt, security, default, and latest acknowledgement. So in fact, for the creditor, Form C actually has been modified, and there are total of 94 questions which are being asked along with the declaration. So the kind of filing of information by a creditor for a person, like for a company or any other person, actually is getting now, it actually giving an opportunity, professional opportunity, that there can be some people who specializes in submission of Form C, so that the information is submitted to IU, and it is finally a record of default is issued. Now, the issue 4 is the proper due diligence by the IU before issuance of a record of default. So far, I believe such kind of due diligence was not mandatory, because the submission of documents were not mandatory. Now, the submission of document will become mandatory. So therefore, the due diligence is also mandated. The IU will verify. IU will verify the financial information such as the email ID of the debtor, proof of the debt, proof of the security, latest acknowledgement, and proof of default before issuing the record of default. So this is also another amendment. And then the issue number 5 is issuance of record of default in case debtor disputes the information of default. Then even if there is a dispute, then in the case of dispute also, the some kind of ROD can be given if it is a partial dispute. Here, I would like your indulgence that in case it is disputed, then what happens? But the last but not the least, issue number 6 is incorporating additional details in the record of default that actually would be issued by IU. So I think in the last two issues is okay, but what is the actual record of default that you would issue in case it is disputed? Yes, Mr. Chaudhary.
No, yeah. So what here the discussion paper proposes that the debtor has the option to accept part of the default, and if he accepts part of the default and says the remaining is disputed, so the ROD, the record of default, will be issued for the undisputed part. So basically, the amount will be broken up and into disputed and undisputed amount. And if the debtor says that I have defaulted and this part is a dispute about, and he specifies the amount, so that the ROD will be issued for the undisputed amount.
So, Mr. Chaudhary, there are many questions, and we will actually extend about 2 minutes to handle these questions. So, the first question is: can NeSL services be used to personal guarantors cases also?
Yes, very much. So, in such cases, yeah, it's a very good point, and happily the person has brought it out. So, in this case, what will happen here is that the person guarantor should be treated as a debtor. So, you have to invoke the guarantee, you have to give a notice, because for the application to personal guarantor, these two details are required. Then you have to treat him as a debtor and file a Form C with the personal guarantor as a debtor. And in the details, you can give the other details like the date of invocation of the guarantee. This is a very important provision. Please do use this facility because there are a large number of PGTCD cases coming up.
The next question is from CMA ML Jan. He is asking: is it mandatory to obtain certificate of dues from NeSL for filing the IA? I think what he's trying to say is it mandatory to obtain record of default for filing the IA under section 9 or 7? I can modify the question.
IA means what is it?
IA means the application. IA is the interlocutory application.
Yeah. So if it's an application for initiation of CIP, it's mandatory to file the information of default. But as we are aware of section 7 or 9, you can use the ROD or any other information as provided for in the CIP.
So when I said that the intent of the BLRC or the original lawmakers was that to create a competition amongst IUs. So presently there is only one IU. However, the financial information services, there are 5 such companies. So the question which is coming is from CA Arayan Gupta. And the question is: multiple IUs may create the problem of multiple search. Can there be one repository for the information to be uploaded? This is question to you technically, because in case there are multiple IUs, then what happens?
So the question is, CICs have been in existence for more than 50 years. IU has started with IBC. So maybe we'll see when, it's only 6 years now. And after this, we went through a process of building up the IU and then strengthening it. So we took certain measures in 2019, we took measures in 2022, we took measures in 2020. And one more,
yes, please. Yes, please.
Yeah, one more thing I'd like to emphasize is that NeSL is the only IU, not by design. The design, in any case, provides conflicting rights. It is only by coincidence. So going forward, we may have co-IUs. In fact, CICs have come up over a period of time.
Yes.
So who knows, in future we may have multiple IUs.
So Maharaj Kumar is asking, please appraise the process of acknowledgement of credit as mentioned.
Acknowledgement of credit. What is
acknowledgement of debt? Because see, like when we say that the IU will verify and will ask the document regarding acknowledgement of debt. That is what is the question.
Yeah, it's still not very clear, but let me just explain it this way. So when a financial creditor submits information and the debtor acknowledges the same, so that can also be a proof of acknowledgement of debt. The reason is the 2 essential features of acknowledgement of debt are complied with. One is the right person is doing it because we are identifying the person who is doing it. And two is done under the digital signature of the person acknowledging the debt. So yes, it can be treated as a transfer privilege.
So, Mr. Chaudhary, now in the proposed in the discussion paper, we are proposing that the schedule 2 only will have two colors. One is green and the other is red.
Yeah.
Earlier, I believe there was a color which was yellow also. And that yellow actually used to mean deemed authenticated. Now, there will not be any clause like deemed authenticated, because once they are, is that something that you are now proposing or IBBI is proposing?
Yeah, I think that is implied, although it's not specifically mentioned. So it is that is implied, because if you see, even the for the disputed also they have broken it up. So idea is that and for financial creditors, of course, it is said that it can even for dispute, dispute will also not be accepted if there is an acknowledgement of debt. So it is implied that there will now be only two categories: accepted and dispute. And even in the disputed also, if you accept part of the amount, it will be treated as accepted.
So you see, like we keep on getting, we are getting questions and questions. I mean, whenever you are tired, we can close it, or we can actually a hard stop at 12:10.
I can go on as long as you want.
Okay. Then let's see again. Lalit Maheshwari is asking: is ledger account, if ledger account is filed of the debtor, will it be one transaction or all transaction included in the ledger account?
Yeah, I'm not sure whether it's for the operational creditor or financial creditor, but typically, as far as the bank is concerned, one ledger is one account. So it's like a bank statement. You can give a bank statement of one account. So and you don't find the transaction details. You find the details of the account. Means, say you have taken a cash credit account. So you don't have to find the details of transactions in the account. You find the details of the account. For example, the amount of loan taken, the kind of security you have engaged, the date of sanctions. So these are the details you will find. But if there is a default, then it becomes a specific event. Then you have to give certain other details like the date of occurrence of default. So all those details are required. Then it becomes a specific event.
Now, see, another question is very important. Like, if there is a difference in the amount when the notice is given under Section 8, and finally, when the record of default is issued by the IU, and in case there is a difference in both amounts, then what happens, according to your experience, Mr. Chaudhary?
Yeah, so my experience is that the ROD is only for admission purposes, and actual adjudication of the claim is left to UIPs. At this stage, we are only looking at the amount of the claim and whether there is any for Section 9 application, whether there is a pre-existing dispute. In fact, I have seen a case, a financial creditor case, even if it was disputed, it is admitted, provided that the amount is 1 crore. That is not financial creditor. In operational creditor, of course, is a pre-existing dispute, which you cannot.
So Naveen Bhatia is asking, is it mandatory to file the records of IU before filing the claim under Section 7 or 9? So it is not, but when we are seeing the regulations where the documents what are required to be submitted to RP or the liquidator, then one of the document is records of the IU. And if it is not available, then the liquidator will take the call whether the other documents submitted are sufficient to admit the claim or not. Then we have the Sandchit. What kind of information is mandated to be submitted by the financial creditors to IU? In which format, and are there any deadlines to submit the same? Which sections in the code or some other law cover these aspects? Because I think some banker is asking, because maybe that he's not aware that all the banks are required to submit this information mandatorily to IUs.
Yeah, so I'll start with the last one, Section 215.2 of the code. It says a financial creditor shall submit information. And besides, of course, as I mentioned earlier, there is a circular from RBI advising all banks to comply with the provisions of the code and submit information. What are the other two questions?
So the no, this is the only part. what sections in the code or some other law cover these aspects? I think you already said the section.
Yeah.
See, the other question is from Lahari Anupam. Anupam Lahari he's a secretary with NCLT. He's a secretary with the NCLT. He says that is there any till now many applications have been filed for insolvency, maybe under section 7 or 9, along with the record of default from NeSL. Is there any study conducted whether such cases have been admitted within 14 days or slightly earlier than the others? Earlier than the others, I have added from my side, because 14 days in any case we are not expecting when we have to give a notice of hearing.
So I'll only say that there are many cases where the AA has used the ROD from the IU, and if you find list of such orders, it is there on the website also, and AA has specifically referred to the ROD of the IU in the order for admission. Now, regarding this 14 days, I think there are enough judgments to say that it is not binary, it's only direction. So I will not be able to comment on that.
So I think only one question we'll take is see, if there is no response from defaulter related to IU, what will be the further proceedings?
Yeah, so that manner is there in the regulations, which is regulation 21 of IU regulations. And basically it means that we give one original plus 3 reminders with a gap of 3 days each, and after which if he does not respond, then it will be treated as due to work. But after this discussion paper, what will happen is for the banks, it will continue as before. But for other creditors, if the debtor chooses not to respond, in fact, that is one issue which we need to consider here. If you are not a bank, and if a debtor does not respond, does not accept, then you will not be able to get an RO. So that's one aspect you have to consider. And Amilji, one more aspect I think you and your audience must think of. There is this exception provided to banks which are under Schedule 2. Now the code also provides for something called FSPs, which is financial service providers, which are basically institutions which are regulated by the financial sector regulator. So the issue here is, which you have to consider, the audience has to consider, is that whether similar provisions which are at present and as proposed in the discussion paper to be extended only to Schedule 2, whether such provision should not be extended to all financial service providers or FSPs as provided by the code. So that is something which we all need to think about.
So the time is always, we all are slave of time. So we already have exceeded 10 minutes. I thank a lot to Mr. Debajyoti Ray Chaudhuri, the Managing Director of NeSL, for providing this information and awareness to every participant of ours. Thank you very much. And we normally say, Mr. Chaudhuri, that this is our way of learning, nothing else. Thank you. Thank you very much.
Thank you, Mr. Goyal, for having me here, and thank you for all the audience for logging onto this. Thank you.
Thank you, Ji. Thanks a lot.